time frames when they were really trying to get the location. And it seems to me that law enforcement needs to take the bull by the horns initially and narrow the search, because that's the way search and seizure law is developed up until this moment in time.
Shitting on Moretti's face.
I'm left wondering why they needed the entirety of these social media accounts to identify the owner.
Boom.
That this was fairly broad and he was asking for a lot, so he recognized that we're going to have a taint team, but then that never happened. They just got access to everything and went through everything and decided what was going to be relevant and what wasn't. So
hold on, what? I don't remember hearing that part. The first YNW Melly appeal hearing went terrible for the state. Judge John Murphy suppressed certain key pieces of evidence, most notably cell phone records and related forensic evidence that prosecutors argued tied Melly to the crime. Judge Murphy ruled that law enforcement's methods for obtaining or handling this evidence violated Melly's constitutional rights. Without this evidence, the state's case would be much weaker. I've been saying this forever. The state purposely did this appeal to delay the trial because they weren't ready. Stick around for the last half of this video. The judges start grilling them on certain issues. It gets wild. Hit subscribe. Let's go.
We have got to the point where literally anybody can build a fully working app without knowing how to code. This is base 4.
Shout out Seti Nash for this footage. So yeah, go subscribe to him. Let's get right into it, boys.
We have 3 cases set for oral argument this morning. The first case is the state of Florida versus Jamel Demons. Jamel Demons. Thank you, Ms. Howard. You're not used to sitting.
If you're watching this video, make sure you hit that like, subscribe button.
In that chair. So are you ready to proceed, counsel?
I'll never forget in the first trial, suddenly there was a switch where, no, his name is pronounced Demons. I feel like the defense suddenly switched the pronunciation of his name for the jury. So this is a prosecutor.
Attorney General Yesenia Concepcion on behalf of the state, and I'd like to reserve 5 minutes for rebuttal, if I might.
Remember, this is a battle for evidence coming into the trial, so let's go.
As to standing, before invoking the Fourth Amendment's protections, a defendant must establish standing, showing that he has a legitimate expectation of privacy in the area to be searched or items seized. And at his first trial, the defendant disavowed ownership of the phone, which included the iCloud account, social media, sort of those attendant. And the lower court, which had presided over the first trial, in these proceedings agreed that the defendant had, quote, was basically saying it wasn't his phone. And so, despite never having affirmatively claimed ownership, the trial court here found that because he disavowed it once, but didn't disavow it again, that was tantamount to claiming ownership and a privacy interest in the phone. That's simply not what the law requires. So in this case, the defendant never made that initial showing of establishing ownership and his expectation of privacy. And so that's sufficient for this court to reverse the grant of the suppression motions on that basis alone.
Did he take the stand at trial and testify that that wasn't his phone?
That was just the theory, was that the state had not proved that the phone and the social media accounts were.
It was the position that the lawyer took in the different lawyers, of course, but right? What didn't he get?
I don't know if it was the same or a different counsel. Okay. I'm not sure. I don't want to
That's what they said. The lawyers said in the first. Okay.
That was their theory. It's not his phone. You haven't proved it's his phone. So certainly he didn't claim ownership of the phone to establish standing. And the same here. He never claimed ownership of the phone. And the court, instead of saying you've shown, your ownership interest, your privacy interest, said, well, you haven't not shown. So that was the crux of the error, basically. And so as to independent source, the purpose of that exception is to leave the police, state investigators in the same position, but not a worse position, if there had been no error with the warrant at all. So here there are several independent sources, which left investigators with all the same puzzle pieces that they would have had, even if the court, years after the execution of most of these warrants, wouldn't have found that it needed to have a narrower temporal scope. So not that the warrants themselves were bad, but that the time period was too broad. The strongest, and there's several, and I'm not going to recount my briefs as the court has reviewed them, but the strongest sources were the victim Anthony Williams' phone, which contained not only the cell site evidence, which showed they were traveling together and then weren't at the same time that Mr. Damon's phone was moving in the same way, but showed the communications between them that were ultimately suppressed when they suppressed the iCloud results.
Remember, the suppression of evidence was just closing the time period down for a lot of evidence. It was down to a 6-hour window instead of months or a month or two. For his Gmail accounts, for his text messages, it was everything. And this is why the trial is delayed, so this is all very important.
Were longtime friends that they were having a dispute over money, over the direction of their rap group collective. Those same messages would have been found and were found independent of Mr. Damon's phone. The same with public social media posts regarding gang activity, regarding...
one of the problems that it would seem to me the state has on here is that isn't the...
For the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
It really relied on Detective Polo's testimony to develop the independent source.
Detective Polo, the guy with the mask, that his identity was leaked.
And Detective Polo came into this case at least 4 years after the shootings, and with the benefit of 20/20 hindsight was going back and sort of looking at it, and it seems to me he was saying what he would have done had he been on the case. But, couldn't the judge reject, or don't we have to assume that the judge rejected Detective Polo's recreation of that and deciding that inevitable discovery and independent source were not appropriate. I mean, he could have rejected Polo's testimony because it was after the fact and wasn't even involved in the case at the time.
Damn, Polo's testimony was rejected by the judge.
The source specifically looks at either before or after the initial search at issue. So it just has to be independent. And Polo came on board, I believe, when the superseding indictment was filed, which added the gang enhancement. And so it now became even more relevant to get this information, the gang-related information. And when we look at what he looked at, everything that he looked at was available or would have been available to Moretti when he did his first 13 warrants, the ones that are at issue here. So he's looking at publicly available social media posts. He's looking at those communications in the phone interactions that we already have from either the co-defendant or the victim's phones, and looking within Moretti's, applying the temporal restriction that the judge from there was able to get all of the same information. So independent source is not defeated by the fact that his investigation came after, merely that it's independent. And it obviously was independent, right? Because he's looking at a slightly different angle because he is concerned and his expertise is a gang involvement. And he's also involved in the tampering case, looking at what he was doing in terms of tampering with witnesses. So the fact that we have those independent sources and that Polo is independent of Moretti, I would say helps the state's case. And the case law is clear that the independent source can come after as long as it's independent.
You use the word would. He would have had that information available to him. But isn't that easy to say in hindsight? And how do you distinguish between every case in which, sure, in hindsight, vision is 20/20. Mm-hmm. So looking back on it, Detective Moretti can say, sure, I would have done this and I would have done that. But what framework are you suggesting for if this were to apply to every warrant, if the state were to always say, well, we would have found it through an independent source, now knowing what we know? Why don't you look back to what they knew then and what they actually did then or would have done without having benefit of hindsight? Mm-hmm. See what I'm saying? What framework do you suggest for every warrant?
Well, and I think in this case, it's crucial that the investigators had all of these pieces already. So they already knew that this was potentially a gang-involved shooting, that Mr. Damon specifically was involved in a specific gang that they named.
Quick delivery matters to your customers. That's why we've expanded our U.S. product range and fulfillment. Your go-to.
We all watched the first trial. There was no evidence that shooting was for a gang. Like, there's no email saying, yo, you got to do this to get initiated. There was none of that. Melly was communicating with gang members in his email, but like I've said 100 times, this was an emotional situation if Melly really did it. Like, he killed them out of something popping off emotionally, business shit, or like something popped off. I don't see Melly executing his two best friends for a gang.
They do have all these pieces, and the warrants that they were traveling under included these communications at in this time. So he did not obtain those warrants because he didn't need them because he thought he already had material from these warrants. And we can absolutely see a world in which you can say, well, I would have done this, and that's not allowed. But here we have very specific testimony where Detective Polo goes piece by piece. This, for example, the Facebook post with the defendant and his co-defendant, and they are wearing shirts that commemorate the victim's death, and they're talking about the victims. That specifically, he says, that would have led me to believe reasonably that they are having communications on Facebook about these murders, and then that would have led me to seek a warrant for these murders. So I think in this case we have a lot of specificity. I'm sure the court is aware that the hearings with Detective Polo were quite long and quite involved. So it was more than mere, yeah, we would have done this, we would have done that if we didn't know. These were the investigations he was already doing before the motions to suppress were filed, and I think some of the cases talk about that. When are these independent sources coming up? Is it before or after a motion to suppress is filed and you're scrambling to kind of find something else? That's not the case here. These investigations were ongoing, and he was already pursuing these materials that were publicly available, so therefore an independent source, and already in the state's possession, like the victim's phone, co-defendant's phone.
Fall is here, and it always feels like it's a busier time with shorter days and busier routines, and finding time to cook may be tough, which is why I love Factor. Their chef-prepped, dietitian-approved meals make it so easy to stay on track and enjoy something comforting and delicious no matter how hectic your life gets. You can choose from a wide selection of weekly menu options, including premium seafood like shrimp and salmon at no extra cost. They have meals for pretty much any diet you can think of. If you're someone that likes the keto diet, or you just want a lot of protein, or you're just worried about your calories, they have the diet plan for you, trust me. My go-to is the Protein Plus option because I like to hit my protein goals each day, and it's really working because when I have lost weight, but my weight in the weight room has gone up. And that's why 97% of customers say Factor helped them live a healthier life. So you can feel the difference no matter what your routine is. Eat smart at factormeals.com/coach /KindaFunny50 off and use code KindaFunny50 off to get 50% off your first box plus free breakfast for 1 year. That's code KindaFunny50 off at factormeals.com to get 50% off your first box plus free breakfast for 1 year. Get delicious, ready-to-eat meals delivered with Factor. Offer only valid for new Factor customers with code and qualifying auto-renewing subscription purchase.
Benefit to anyone to exclude the things the state already had. And I think that distinguishes this case from others where maybe they don't have that, or they go out to seek it after a motion to suppress has been filed.
All right, here's Melly's lawyer, Carrie.
How do you feel about standing? How do you respond to this?
Well, I find it so curious that issue is even raised, because if we look at the record of the hearing in front of the trial judge, which is why the trial judge did not even address standing, the state specifically said, at one point, I do raise the issue of standing. I'm withdrawing that argument. That was based on misapprehension of the ownership of the devices, and that's just in 10 and 11. And that is on R3347. So I would submit that the trial court did not address standing because the state specifically withdrew that argument.
Ooh, I think I remember them doing that, withdrawing that in court. Interesting. Fire 'em back.
Very difficult now to recreate the facts for standing, not for standing in front of all of you. So I would submit the state has waived that argument, not even waived it, withdrawn it in the trial court. And so it's not an issue. As also argued in the briefs, the affidavits themselves establish standing, as they all allege that the phones are Jamel Demons, the various social media accounts are Jamel Demons. So I would submit that the affidavits also support standing. I think this case really presents sort of the classic modern day Fourth Amendment concerns from 1789, right? Where the concern of the government being able to rummage through a person's most personal information and most extensive, frankly, more extensive than what you might be able to have in a home back in the 1700s.
Yeah, I mean, Moretti's search warrants were very broad. I mean, one of them was like years, I'm pretty sure. Like from the history of the entire phone or something. Or maybe it was a Facebook. I think it was the Facebook or Instagram where he could see years of everything.
Limited by a warrant. It has to be limited by a warrant that has probable cause to believe there's a crime, and that particularly describes what is to be searched. Probable cause to find a gun doesn't allow law enforcement to look at a diary just because it may be interesting to know what does the suspect think, do, know, what are their activities, and that's really what most of these affidavits support. You know, in terms of leaving to the unfettered discretion of law enforcement, the affidavits themselves really lay out that that's what we're asking for. We'll decide what's irrelevant. We want all of this information. We'll go through it and decide if there is information that supports our investigation. So while we do take issue with the trial court's adoption of the severability doctrine, which I'll spend a minute or two at the end talking about, you have to respect the painstaking efforts this trial judge took to consider the lengthy written arguments, read the 13 affidavits and warrants, and listen to 2 days of evidence initially, write an extensive order, the omnibus order, addressing each warrant individually. And they all have different time frames and different matters. The trial judge went through specifically to address what information was sought, what was obtained, and what did the affidavits support. The trial judge considered the individual circumstances and the probable cause, and then the trial judge allowed essentially a re-litigation with inevitable discovery and independent source that should have been raised initially. It is why Judge Murphy's order comes to you with a presumption of correctness as to the determination of the facts. Quite a bit of argument in the brief as to the appropriateness of even having the reconsideration hearing that litigated the only issues the state is now arguing, independent source and inevitable discovery. I leave to the court that issue, as you're the purveyors of the rules of procedure, but it appears the state's argument really primarily was raised under the guise of the motion for rehearing and reconsideration, as these doctrines were not even raised initially. So apparently the government accepts the court's ruling regarding the overbreadth of the warrants and relies on independent source and inevitable discovery. The trial judge did not find much value in the independent source, and it appears that the state's argument is not that the evidence, which is all of the evidence that was subpoenaed, right, all of the phone records, all of the social media, not that that evidence would have been independent, that there was an independent source for, but that there was an independent source for another warrant for those items. And I would submit that is not the purpose of the independent source doctrine, that the purpose of the independent source doctrine is really, I think maybe this court in Carter addressed it, where the evidence of I think it was Carter, the tag, yes, there was evidence obtained from a driver's license, but the tag was totally independent from the driver's license, and that evidence was obtained at the same time and was used to connect the suspect to the crimes.
Let me explain the independent source doctrine. It allows evidence obtained illegally to be admitted in court if it's later discovered through a separate lawful process that is not influenced by the initial misconduct. For the doctrine to apply, the evidence must exist and be discoverable through constitutionally valid means, like a separate warrant, even before the illegal act occurred. This rule aims to balance the goal of admitting all relevant evidence against the need to deter illegal police actions, ensuring officers aren't put in a worse position due to their own errors. It reflects a societal interest in admitting all probative evidence of a crime. So it sounds like they're saying Detective Polo was going to find certain things later on through Facebook or Instagram, Snapchat, Gmail, and they're arguing over the admissibility of all that. And that's me as a dumbass ginger trying to understand this.
Independent source, the trial judge found the state was sort of conflating the two. I will admit the case law is at times sort of mixed. I believe what the U.S. Supreme Court has said is that inevitable discovery is sort of a part of independent source. But essentially the government argues that Polo's investigation 4 years later into gang activity would have uncovered the same information if he had obtained a warrant supported by probable cause and with particularity.
So I was pretty much right. That sentence summed it up.
Since that was never done, we don't know if that would have occurred.
Aren't most of the independent source cases and inevitable discovery cases, don't they, it seems to me that they involve like the police officer goes and runs into a house on exigent circumstances, but the police are already in the process of getting the warrant. So the warrant, that whole process is in place, and the judge, it's easy to look at and say that, oh yeah, they would have found that. Isn't this kind of a unique application of that?
I would say yes, it is a very unique application.
Yeah, if that's usually how it is, just police officers running into a house when they would have already gotten a warrant anyway or whatever. This is all digital evidence that he would have found later on.
You know, what we do know from the cases that address and as I say, some of it is interchangeable, but independent, inevitable discovery, like Rodriguez, that there has to be a showing that that investigation was already underway. So the warrant they were already going for, even though there was an illegal entry into the home, and the warrant was obtained without any of the information from the illegal entry. And, you know, the Supreme Court in Rodriguez, this court in Roll, has always said you have to show that the investigation was being actively pursued at the time. So what we have is Polo's investigation 4 years later, not actively being pursued at the same time that Moretti is pursuing the warrants and obtaining all of the information that he did.
It's literally years later and a different detective.
It's the retrospective analysis. Detective Polo didn't just look at the publicly available information to come up with his opinions. He had already reviewed, and this is in the record, all of the data that had been obtained pursuant to the warrants that the trial court had then ultimately ruled had to be temporally limited. He then went back to the information and superimposed the temporal limits that the court ruled on, and then said, based on those temporal limits and all, oh, I could have done this or I would have done this. It's so much speculation, it's so much hindsight, and frankly, it's, you know, and I don't mean to impugn Detective Polo in any way, but we have to assume he put out of his mind all of the illegally obtained information that he already had reviewed, and I just don't think the courts are expected to do that, especially with an investigation 4 years later on a separate topic. And what the trial court was concerned about is that Polo's investigation was really about the gang enhancement that is alleged in the 2020 23 charges.
This is all over the place. It's for the 2023 witness tampering charges. She's kind of cooking right now, I'm gonna be honest.
Because even he would have limited his warrants to information related to the gang investigation. So then we have two separate things that we're even investigating, and what evidence would have been relevant to the homicide versus the gang investigation. I think this is why the courts do say you have to show you're actively pursuing the same information at the same time as you obtain it unlawfully. And I think that the trial court really, you know, patiently listened to another day of testimony from Detective Polo, overruled for purposes of the hearing repeated objections to speculation, right? Because Detective Polo routinely said, well, I woulda or I coulda or shoulda, and the defense objected to speculation. Trial judge said, yes, it's speculation, but I'll allow it for this hearing. But in conclusion, he ruled it was all speculation, that Detective Polo's testimony was based solely on speculation that he would have done these things. We might be in a different posture had there actually been, at the same time, warrants issued for the gang investigation, and we could compare, was there an independent source? Would it have been inevitably discovered? But instead, we're going 4 years later and looking back on it.
You guys know how I feel about a gang expert. Remember the gang expert bullshit and the YSL trial? Gang experts are horseshit. I'd say 99% of it is speculation.
Didn't the trial court save the state's bacon by narrowing the temporal application of the
Yes.
of the thing? Why you need to address why that's not why that was error or why we shouldn't do that.
And thank you for not so good with clocks. So the temporal severability issue is a novel issue in Florida. The trial court cited a footnote in an older case. Severability has been used in other contexts, like legislative enactments, things of that nature. But in terms of in Florida on warrants, it has not been used. And I would submit for policy reasons, right? Because it really would encourage law enforcement to just go get everything and then let the trial court make the decision. Well, now we know this is relevant or this part is appropriate, rather than once it's found to be overbroad, the entire warrant should fail. And so I would submit that is a novel issue in Florida. The federal courts have addressed it and have addressed it in various ways and with various limitations. And I'd finally note the trial court did note on the severability issue that you should weigh how much information was obtained lawfully within his, the time limits that were imposed versus unlawfully. And there's really nothing in the record that tells us what that is, but I would point to specifically.
But here's, in doing that analysis, let me just interrupt you. He's, what he wanted the warrant for was to pin down the location of the defendant. And so it seems to me that in the drop of all the evidence, that all the location testimony is going to be, that's relevant, is around the time of the shooting. And the stuff that goes back to, October 1st or anything, that's really not relevant to the location at the time of the shooting. So in weighing the testimony, why couldn't the trial judge have decided that this was the relevant evidence, this is what they were looking for, and that, that this served the proper purpose?
So the state's omnibus opposition brief specifically raised temporal severability. Even if the judge agreed the warrants were too broad, which he did, and he changed the time frame down, the court should admit evidence within the properly supported time windows and suppress only the rest.
Disagreeing with you if it was just the day of or the day after, but there are a number of these warrants that stretched and the trial court ends up allowing for a couple of months. And I would submit that those, I know on the motion to suppress number 11, which might be Gmail's, I had to look at my notes, the court said the vast amount of data obtained compared to what would be relevant. But there's really is not, appropriate. But then he does limit it, but to like a 2 or 3 month period. And I would submit that there should have been a specific weighing. Was there much more data gathered illegally than what was important for and supported by probable cause? That's the standard that has been accepted by several of the federal courts and that the trial court cited. But that analysis is not contained.
See, my last question, I got that, I understand your answer. My last question is this, you talked about the policy that, would be implicit with this. And this is a quote from, so I had to read all these federal cases to prepare for this because there's not much in Florida.
So she kind of cooked there. She's frying Danny Polo for saying he would have found this shit anyway. Some shady practices down in Florida, bro. That's all I'm saying. But let's see what the state responds with.
The problem that I'm having with these warrants is that initially they were so broad. That I was surprised that the trial judges signed these warrants for the timeframes when they were really trying to get the location. And it seems to me that law enforcement needs to take the bull by the horns initially and narrow the search, because that's the way search and seizure law is developed up until this moment in time.
Shitting on Moretti's face. We've all been saying this for years. Moretti's search warrants were way too broad. And here's an appellate judge agreeing with all of us.
In this case, why didn't the trial court save the state's bacon, as I asked Ms. Howitt, by narrowing the temporal time of the warrants? Because these warrants were, there's no way a month before anything in any of the information would have helped their initial detective locate the defendant at the time at or around the shooting. You just can't make that argument.
Well, I think when we look at what, especially in those initial warrants, what Moretti is looking at, so it's not only his location, it's location, and then there's a progression in the warrant applications. And first it's,
they're looking for a motive.
Up and people are dead, what's going on? And so this is all you know. So you're like, okay, well, let's look at the phones of the people in the car, their locations, and then you get to the location, you get to Mr. Damon's phone, and then you see that he is communicating constantly from the lead up to the murders, to the execution of the murders, and thereafter.
But why shouldn't courts require law enforcement to start narrowly, around the time, use information that it obtains to go back and get warrants later that broaden the scope of what the law enforcement is allowed to search?
Well, I think when you read the warrants together, I do think that's what's happened here. We started small, and then with more information, it's like, okay, now we have cell site information, so we know where you were. And then we find Mr. Withers, for example, who's talking to Mr. Damon's on Snapchat, and we know he's communicating through Snapchat.
But the initial evidence drop, was huge. And didn't the first detective have to go through, hundreds of thousands of pages of data, to really find out what was relevant?
Right, and I think that's the nature of the way they receive this evidence. So another thing that we haven't addressed, but another job of the state is to identify the owner of the accounts, the phone. And you need, I think they call it, I don't know if proof of life is the right term phrase, but so you need some space outside. We're not talking about a year before. This is like 3 weeks before the crime. And the phone itself, the iCloud account, only existed since August. So this is really a case where you cannot possibly say, well, we're going to get your entire life forever and ever.
But the point, if I understand Judge Gross's question correctly, is even 3 weeks was arbitrary in the trial judge's determination that there was no relationship provided as to why the 3 weeks point was just, well, let's just go back a certain amount of time. And there's no probable cause for that.
And I think that's where it was to establish the identity and the owner of the phone. I think that was the basis that Moretti, and I remember Polo also said that, but I believe that's what Moretti testified to. And so you also have the officer testify, also with Moretti, that the way they receive this stuff, it's not sorted for you by, let's say, Apple, and you say, well, only give me this evidence of the crime. They just don't have the capacity to do that.
But couldn't law enforcement be required, let's say with Apple, for example, who
Have you ever wanted to see your home from space? With this free satellite Earth Maps tool, you can zoom right down to your
they've got some pretty smart people working at Apple. Couldn't they give them certain language parameters, like certain keywords, and have them, I don't know, I don't do this, but have them conduct a search in that way, subject matter, narrow the parameter of the search? Because there's temporal, but couldn't they, if they gave it to Apple, couldn't Apple search according to those language parameters?
I don't think Apple would do all that. Maybe the search warrant shouldn't have been months.
Testimony was that they could not, that they didn't have the capacity
But
to
that
sort.
came from the cop. That came from the
and there's nothing to contradict that.
Well, I mean,
right?
it would be different if it were somebody from Apple. I mean, right?
And the defense attorney had the opportunity to present that argument or evidence, but the only evidence we have, the uncontroverted evidence we have from the testimony of Moretti, is that it cannot be sorted in this way. And
Couldn't the judge assume that we generally all know now that cell phones track your location? I mean, that didn't need to be proved. And I mean, wouldn't it be similarly?
I don't think so.
Assumed that that Apple could track could conduct a search based on narrower search parameters set up by law enforcement?
I don't believe it's the same. We don't use that technology the same way we use, if I have Google on my phone and I'm using Google Maps to navigate to the courthouse, I understand that information is saved in Google. I have no idea how Apple, and I'm not very techie, so maybe that's why, but I have no idea how Apple stores, keeps, sorts, tags their information. And so I don't think that that's within the common knowledge of, a judge issuing a warrant. It is within our common knowledge. I think most of us use the GPS on our phone now, so I think that's within the common knowledge, but I wouldn't say how a software company keeps and tags its information would be commensurate with that.
But going forward, don't you think that, like that quote from Salih Esweza, those are the types of things that law enforcement should become cognizant of in obtaining warrants?
I don't know how.
When you do a wire, just a wiretap from the old school stuff. I mean, there were very narrow parameters that were allowed on the wire. You couldn't listen to every call.
Right, but
the concern here is that the police are looking at everything that's dropped on the cell phone, and
I think in the wiretap, the police are in control of when they're listening and how they're listening. The police are not in control of how Apple keeps its records and how they.
But they didn't try, right? He didn't try. It's not that Apple told him no. It's that Apple can't do it. But there was no evidence that they requested either a temporal limitation or search terms, and Apple turned them down. And I think the point is that as we move forward, why aren't these things that law enforcement should be trying while trying to balance the Fourth Amendment protections? And, I'm left wondering why they needed the entirety of these social media accounts to identify the owner, or proof of life, as you said. I mean,
Boom. Why do you need years and years of his Instagram and Facebook for proof of ownership? That's horseshit. You don't need that broad of a search warrant for that.
That could be very narrowly tailored. In fact, they said they were going to have a taint team. So the detective clearly knew that this was fairly broad, and he was asking for a lot. So he recognized that we're going to have a taint team, but then that never happened. They just got access to everything and went through everything and decided what was going to be relevant and what wasn't. So
hold on, what? I don't remember hearing that part. The taint team never happened for this evidence? There was supposed to be a taint team, and that never happened. I don't remember reading anything about that.
How do you justify searching the entirety of somebody's social media account for something as narrow as identity?
Well, and I think we have to go back with what we have in this record, and it was the Moretti's testimony that in his experience, they don't have the capacity to sort, and so we have nothing to say that they do, right? So I think there's just no way to do anything other than take that as this experienced officer's experience in obtaining warrants. And in terms of the social media accounts, they were tailored because I think the focus was communications. What are you posting about? What are you commenting on? And who are you talking to? Because we have probable cause to believe that you are having conversations about not only committing the murders, so the premeditated design to commit the murders, the accomplishing of the committing murders, and then covering up the murders after the fact. So in this case, it's not just a broad, well, who is it? It's like we know, and the warrants go through, this is the specific trail I'm following, and I have probable cause to believe that they're having these communications on these platforms with this person and what they're talking about. I don't have the same reading that it's this broad, anything and everything you've ever posted on social media or anything you've ever said on social media. It was focused. The earliest was October 1st, was like the earliest date that was requested, which is a few weeks before the murder. And like I said, I think in this case, the independent source is so strong because we have complete untainted communications sitting there in these devices that were not obtained through these warrants that Mr. James would have no standing to contest, and they contain the same information that is the definition of an independent source. And so there is just no benefit to anyone, to society or investigators, to suppress when the evidence is literally sitting in the exact same phones that are already in police custody. Can I just very quickly make a point about the standing, that the withdrawal, as the standing, contesting the standing was only as to suppression 10, which is the physical device of the phone, and that's because there was confusion with the whatever the number of the phone was. But you can see in the motions for reconsideration, specifically standing was contested on all the relevant motions that we are contesting. So with that, we ask that you reverse. Thank you, Your Honor.
Okay, thank you, folks. We'll take this under advisement. Counsel, very well argued by both sides.
These judges just took a shit on the state's face. That's what I gathered from all this. I've called this out for over a year. The state did this appeal to delay the trial in on purpose. I'm telling you, this was all planned for Miss Buckaloo, the new prosecutor on the case. Remember, she had like a 2-week time period to get ready. She wasn't ready for the trial in time initially when they did this. So they were like, fuck what, we're going to appeal this shit to delay the trial another year. And now it's delayed another year now. So they've gotten like a year and a half, 2 years extra time to prepare for trial.
I'm gonna stop it right there, man. Y'all let me know what y'all think about this video. Make sure you like, comment, subscribe.